And one of the big issues that we see on a regular basis with homeowners associations is basically they do not like rentals. And more specifically, they don't like short-term rentals. And they're always trying to change the rules and regulations of the community to eliminate short-term rentals. And at times, they're able to obtain enough votes to amend the CC&Rs. To amend the CC&Rs is difficult generally because you don't need just a quorum at a meeting to amend or alter the CC&Rs. You actually have to have the requisite number of owners within the community to vote in favor of the amendment. So that generally requires anywhere from 50% or 51% of all of the owners within the community, or sometimes it could be 2/3 of the members or 70% or 75% of the members within the community who must agree to amend the CC&Rs. So more recently, we're seeing homeowners associations working to amend the CC&Rs instead of trying to pass rules and regulations. And the reason is because rules and regulations cannot be utilized to restrict rentals or restrict property rights within the community. The rules and regulations are going to be trumped by the declaration. So if the declaration is silent on rentals or short-term rentals within the community, you can't pass rules and regulations as a board, which are going to restrict the use of the property in that nature. Instead, you have to amend the CC&Rs. So these communities are going around and trying to amend the CC&Rs to restrict short-term rentals within their community. And some of them have actually been successful in doing it. And we've started to see litigation in our Superior Court here over the validity of those amendments. Well, Arizona, specifically our Supreme Court, came out with a recent decision called Calway versus Calabria Ranch HOA, which doesn't specifically deal with short-term rentals or rental restrictions, but the nature of the case and the holding of our Supreme Court goes a long way to basically limiting the power of homeowners associations from amending the declarations to restrict the short-term rental of units within their community when the original declaration is silent as to the use of the property in that way. So in the Callaway case, the homeowners association there basically said, okay, we're going to impose certain subdivision requirements upon the owners. We're going to restrict and put onerous conditions upon the sale of properties within the community. And then they put in a number of other restrictions, some of which deals with livestock and things like that. And so the homeowners who were burdened by this amendment to the CC&Rs, they decided, okay, well, we're going to go and file a lawsuit. And we're going to challenge the validity of these CC&Rs. And it went all the way from the Superior Court to the Court of Appeals, and then all the way up to our Arizona Supreme Court. And our Arizona Supreme Court struck most of those amendments. And when I say struck, they didn't just keep them in place for future owners and say, but retroactively, we're not going to impose them on the current owners. They actually took, what we call blue line. They blue lined the amendments so that they're unenforceable and not even part of the CC&Rs or declaration going forward. Now, I'm using some legalese here, so I want to take a step back. When I say CC&Rs and declaration, I'm talking about the same thing. It's basically the restrictions that are imposed upon the community. Sometimes they're referred to as a declaration. Sometimes they're referred to as CC&Rs, but it's the same thing. It's basically that document that was created generally when the community was created that basically says, here's how you can use your property within the community. So the Supreme Court strikes these amendments and basically what they say, what the Supreme Court says is that amendments must be reasonable and foreseeable. And for an amendment to be reasonable and foreseeable, the original declaration or the original CC&Rs must provide notice to the owners that in the future, they may be subject to the new restrictions. The CC&Rs cannot be silent on the new restriction or the issue. For example, in this case, it would be if we're talking about short-term rentals, the CC&Rs can't be silent on the rental of property, or be silent upon the time frame or time restrictions imposed on rentals of property. They have to actually give some sort of notice to the existing owners that, hey, there are rental restrictions within the community, and those rental restrictions may be subject to being, amended and changed. But if the CC&Rs or declaration don't have any of those restrictions, the HOA under this Calway case would be prohibited from then going and all of a sudden imposing restrictions that otherwise didn't exist. While this is an Arizona specific case, I know there's cases similar to this in California and some other states. So it's something to keep in mind if you are owning property that you're using or intend to use as a short-term rental. Number one, check the CC&Rs, check the declaration, make sure that there's no prohibitions. But assuming there isn't, be aware that there is case authority here in Arizona and some other states that would prohibit the HOA from later coming in and restricting the use of the property in that way.